Number 48, the matter of Nemeth versus K. Tooling. Counsel?
Thank you, Chief Judge Wilson. May it please the court. My name is Jonathan Goldman from Sussman and Goldman on behalf of the appellants. May I reserve 3 minutes for rebuttal, please?
Yes, sir.
Thank you, Your Honor. The order appealed from should be reversed because the Third Department interpreted and applied the state's relation back doctrine in too narrow and restrictive of a manner, and in a way that contravenes the plain language of the relevant statute, this court's precedent, and which undermines the underlying policy considerations that animate the doctrine in the first place.
So, counsel, what's the, as they say, the fruit of a poisonous tree? What's the root of this error?
The root of this error is basically contravening what I think this court held in Buron to be very clear, that a mistake need not be excusable to satisfy the relation back doctrine. The Third Department basically held that because the appellants knew the identity of the omitted party, Ms. Kuhn, and had involved her in a prior litigation, that it cannot be a quote-unquote mistake that satisfies the relation back doctrine.
So is it just the mistake, or was there also an issue regarding the identity of arguments?
So in terms of unity of interest, which is the second prong of the doctrine, that was certainly something that had been litigated below. As I read the Third Department's decision, the majority assumed that the first two prongs were met and decided the issue dispositively on the third prong. Justice Gary, in dissent, reached the merits of the second prong, and I think rightly found that there is unity of interest. That issue has been joined in the briefs on this appeal, and I would submit that there is sufficient unity of interest if this court were inclined to reach that issue.
So was it a mistake of law, or was it an inadvertent omission in the sense of typo?
I wouldn't necessarily say typo, but I think it's sort of a combination of the two. You have a situation where Ms. Kuhn is involved and has been involved with these family businesses for decades, and the application to the ZBA had been submitted expressly for the purposes of the two manufacturing entities to be able to use the property. The decision itself from the ZBA speaks about Kuhn Manufacturing.
She was joined in a prior litigation, right?
Yes.
I think 2013. So was the non-joinder this time because she was inadvertently left off, or because there was a determination she wasn't legally necessary?
With the caveat that I wasn't the drafter of either petition, so I can't speak from personal knowledge, but my understanding is it was essentially inadvertent in the sense that it was not done deliberately to obtain some sort of litigation advantage. The decision of the ZBA being attacked by the Article 78 petition was a decision that granted a variance with respect to the manufacturing entity's application to operate their business from that property.
So you're not saying it was a mistaken apprehension that she was not legally necessary, but an inadvertent omission? Is that right?
I think it's somewhat of a combination of both, but I would respectfully submit that either way you look at it shouldn't matter for purposes of relation back, because I think how the court should come down on this, and I think Justice Gary in dissent got this right, is that when you're speaking of whether or not it's a mistake, it's not necessarily, is it a mistake of law, is it a misapprehension, is it inadvertent? The real question is, was the person omitted intentionally and deliberately for the purposes of gaining some sort of litigation advantage?
And is it your argument that the record here doesn't support such?
I'm sorry, Your Honor, I didn't hear that.
Is it your argument that the record doesn't support a clear strategic choice?
That's correct. In fact, there could be none because she's a necessary party. So there'd be no reason to intentionally and deliberately omit a necessary party if you knew that this necessary party were required to obtain any relief and understood that their omission might frustrate that purpose. There's no litigation advantage or anything that could be obtained by her omission.
So the intentionally and deliberately strikes me at least as an exception to a general rule. And although it's a U.S. Supreme Court decision interpreting 15C, not one of our decisions, Kropsky seems to say that it's not the intent, for the general rule, it's not the intent of the plaintiff that matters at all. It's whether the defendant should have expected to have been joined.
That's exactly.
Interpret it that way?
I do interpret it that way. I agree with that, Your Honor.
So what are the things in the record that would indicate that the defendant here would have expected to be joined?
The fact that she's been involved in these proceedings since the prior proceedings, she's the owner of the property. To the extent she gained a benefit from this variance to her property as the property owner, it was done solely because of the fact that as the property owner, she had to be involved somehow in the ZBA proceeding. It was brought entirely for the purpose of her family businesses. The businesses were established by her husband, Ray Kuhn, and her son, Perry Kuhn. They're continued from the property. She's represented by Mr. Pope. She has been throughout the prior proceedings and this proceeding, along with all of the other respondents. I don't think there's any reasonable way to presume that she would not have understood that, but for a mistaken omission of her from this case, that there would have been an intent not to include her as a necessary party to the extent she was a necessary party. And I would also...
So on that
Yes.
point, that goes to, I think, something I've been thinking about on prong 3 of the test, right?
Yes, Your
And
Honor.
excusable is gone on the, we're in what's left. Now, if we agree with you, if we were to agree with you, mistake of law, mistake of fact, whatever the mistake is a mistake, right?
Correct, Your Honor.
What's left? And I think Chief Judge Wilson's point on the impression given to the defendant here, whether it was reasonable to conclude, I think that's still left. But I disagree with what I think you were saying before, that you still don't have a gamesmanship issue, not in this case, but generally, potential, whereas necessary joinder, because I thought that, and I thought that would read a lot out of the purpose of prong 3, but I think in Brock v. Bua, that old case where we saw the excusable standard or approved it, at the appellate division, they talk about gamesmanship with a necessary party in the sense that you don't join them because you know you can join them later, so you have a lot of runway in this case with a party who may be not as financially able to defend or investigate, and then you join the necessary party later at a point in the case that might foreclose certain avenues. That's what they mention in there in the appellate division in Brock v. Bua, and I think that's still left, even in a necessary joinder case. Again, I'm not saying that's here, but I think that leaves that part of the prong 3 open still.
I think I agree with Your Honor's interpretation of that to the extent that, again, even with the necessary party, and I agree with Your Honor that in this case that clearly can't be the case because there can be no advantage or tactic in omitting the necessary party here. They all have the same defenses. The attack really, it's not a claim being brought against Ms. Kuhn or seeking compensation from Ms. Kuhn or from any of the other manufacturing respondents. It's a challenge to the ZBA's determination, and all of the respondents, including the necessary parties, share the exact same defense that, no, the ZBA's determination was rational and legally supported. This isn't the case. But in other cases, in tort cases, perhaps if there's a necessary party issue, perhaps there could be an issue of gamesmanship, and that might be a factual determination that might arise in such a case. But I think you still also factor in, as Chief Judge Wilson indicated, you look at the state of mind also of the defendant, and would the defendant or respondent, if the case may be, would they reasonably believe that there was an intent to omit them such that they could rest assured that the case has been settled and put away for all time as against them? And respectfully, I would submit what might happen in other cases that could not be found in this case.
Third Department also cited a line of federal cases that drew a distinction between the additional party cases and the wrong party cases. Do you think that's a meaningful distinction?
I don't think so, and I think, again, Justice Gary in her dissent pointed out why that's not a meaningful distinction. And I think the point of the federal cases, and I would also just point out, while I agree, as this court noted in Buren, that our state's relation-backed doctrine is modeled after the federal rule, the federal rule is also written out in Federal Rule 15 and expressly includes mistake in the written text, whereas our statute, CPLR 203, says nothing about mistake, which I think is important. So I think the linchpin in the federal and state cases is whether the defendant had notice. The linchpin is notice. Notice and prejudice, I think, are the two key issues with relation back. And where there's where there's unity of interest, our state, under the statute and the case law interpreting it, says that unity of interest is a sufficient proxy for notice such that you're not going to be prejudiced by late joinder. And therefore, that would satisfy that. So the fact that in the federal cases you have wrong party versus missing party, I don't think that's as germane in this context.
Is this case essentially answered by Buren, or If it's more than that, what's the gloss that we have to put on it? What's the rule that comes out of this case?
Thank you. I think technically it is answered by Buren, and if this court decides that, I think that would be sufficient for our purposes. But to the extent the court finds it's not specifically answered by Buren, I think the new sort of gloss or line is that any mistake, so Buren said, it framed the issue as, must the party show excusable mistake for the failure to have named the new party originally, or is a mistake alone enough? So the question really is, well, then what's a mistake? And I would submit to your honors, to the court, that a mistake is simply an omission, an error, something that happened wrongly, inadvertently, or in a manner because of faulty judgment, inadequate knowledge, or inattention. So really the question is it a mistake, an error, or was it done intentionally for a specific litigation purpose, and now you're trying to bring the person back in for, again, some litigation purpose? That's really the issue, and that's the only time I think the plaintiff or petitioner's state of mind is relevant. Otherwise, the only relevant state of mind is that of the defendant, respondent, as to whether they knew or should have known that the case would have been brought against them. And I think, again, unity of interest is a very significant way of measuring that.
So
And I
is
think that's-
another way of thinking about this part of the rule you're talking, or you're describing, that if counsel had realized that the individual was not included in the pleading, they would have added them? So doesn't that cover, we just made a mistake, it's a typo, whatever you want to call it, or frankly, not to be unkind, but incompetence, right? Didn't realize it at the time, realized it subsequently, as opposed to, yes, I know I could include them. Maybe I know I should include them, what I think is what Judge Garcia is referring to. But I get an advantage for my client by not including them right now.
So, and I think that's an important additional clause on the end of that. May I just finish answering the question? Thank you, Your Honor. So even if it's just, I know the person and I know they should be, but for whatever reason, they're not there, I think that's what Buren said. That's maybe inexcusable, and Justice Gary noted that in dissent. Maybe it was inexcusable, but that doesn't frustrate relation back. But if it was done expressly for the purpose of gaining some sort of advantage or as a tactic or in bad faith, then I think that might frustrate satisfaction of that test.
Can I ask one other question? Of course. You could, though, it seems to me, have an additional category, which is a mistake of law, by which I mean you don't appreciate that the person is legally necessary. And I thought I heard you say that this is a combination, perhaps, of a mistake of law and an inadvertent omission. Is that right?
Yes, I think that's a fair way to look at it. And in those cases where it's a mistake of law, given that you don't appreciate the legal significance, I think the federal cases that we cited and that Justice Gary in dissent cited, which say that even those types of mistakes of law satisfy, I think that should satisfy under the state's rule as well.
Thank you.
Thank you very much, Your Honors.
May it please the court, Alan Pope from Coffin and Gerhardt representing the respondents. I'll start off by saying I think the Buren test is the test as it exists right now that covers this case. And the Buren test only talks about a mistake in the identity of the party. And the case law that's developed from that, if it's a mistake in law, that is not something that fits in the Buren test. So what the appellants are asking this court to do is insert into case law a mistake of law in the identity of the party.
But isn't the linchpin of relation back is notice?
And so, yes, Judge, but when you look at the notice in the case law, whether it's state case law or federal case law, under notice, almost all of those cases talk about the add-on party, in this case Rosa Kuhn, being served within the statutory time period, or in the federal cases under Rule 4 within 120 days. Rosa Kuhn wasn't served at all within those time periods.
So it doesn't matter if she knew of the existence within the statutory period? It's that your argument she had to be served within that period?
That's correct. And factually, in this record, she knew nothing about it. And if I can, I'm just going to kind of jump ahead. If we look at the amended petition, 2016, and that's at I think A41 through A51, within that petition, there's nothing in the caption about Rosa Kuhn. there's nothing in that detailed amended petition that mentions Rosa Kuhn. There's nothing that mentions deed owner. There's nothing that mentions landowner. There's two cursory allegations in that amended petition, a detailed, lengthy amended petition that talks about.
But I don't think the law is limited to whether or not there's a mention of the missing party, and they're just missing from the caption and perhaps some other statement that makes clear that you're suing them. I don't think the law is that narrow.
I agree, Judge, but if I can just get to my point. So there's nothing mentioned there. So our answer comes in, right, on the heels of this amended petition. We raise an affirmative defense. Rosa Kuhn, necessary party, not named. Perry Kuhn, necessary party, not named. At that point in time, if there wasn't gamesmanship, if there wasn't something that's going to be on, they had the absolute right within 20 days to amend that petition, name Rosa Kuhn, name Perry Kuhn, have them served, right? They could have done all that. They chose not to. The first time that they do any of that is 4 years later. So
And is your point with that forecloses the relation back doctrine's applicability because that establishes clearly that this was a strategic choice?
I'm not saying it's a strategic choice, and
Okay.
there's nothing in the record that would say that, but.
Okay, so you
if-
agree
if-
that the record doesn't show a strategic choice?
We just don't have enough to know. But if we're going back to what the appellants are arguing to this court, let's expand Buren to be a mistake of law, a law office failure. That's really what they want, right? But when we go back to the affirmative defense, raise those points, and it was within their control, within 20 days, to redo that petition, name Rosa Kuhn, name Perry Kuhn, and have them served, they chose not to do it.
So
is
if
that a-
you're, I'm sorry, go ahead.
Is that a waiver argument? I mean, it doesn't seem in any way that any case I've seen that that type of issue factors into the case, except for, I think what Judge Rivera was asking you, is this gamesmanship? But that doesn't seem to have been argued here. So how would we factor this into our analysis of the relation back?
I think the bottom line here is the appellants are asking you to insert mistake of law, but within the mistake of law rubber band, they want law office failure to be included.
So here's the difficulty I'm having with the last argument you're making, or the point you made, is if, and I'm not taking this for granted, but if we were to conclude that the Supreme Court's analysis of how to deal with Federal Rule 15C is correct, that is, it focuses on whether the defendant knew or should have known that he or she should have been a party in the case, when you say that 20 days after the admitted party said, we are necessary parties, it's then very hard to say they didn't know or shouldn't have known that they should be parties in the case. So, I mean, that the fact you just recited seems to me to fit right within the Supreme Court's analysis of what matters here.
But never served, right? They had the opportunity to serve, they never served it, so whether you look at state law or federal law, never served within the statutory time period.
Well, if they had been, you wouldn't be in the relation back situation at all.
But I guess the other point I'm trying to make is there's no question there was no mistake in the identity of the party, Rosa Kuhn. And also, we know from what happened in 2013 and what we had in 2016, there was no mistake in law.
So it does seem that that's what your argument turns on, right, is that the rule that we have cannot include what you're calling law office failure, mistake of law.
Yes, that's right. And then when we go to prong two, the unity of interest.
Wasn't
Sir,
that
could
the
you just state-
excusable, I'm sorry, wasn't that what we did in Buren with excusable mistake? Wasn't that a law office failure would be not an excusable mistake, right?
No, in Buren, it really, just like the Third Department, looked at that hard and ruled it's a mistake in the identity of the party, meaning a factual mistake of some kind, right? And there's been case law where the mistake, in fact, of the identity of the party, take the 1983 cases, right? The officer's name is misspelled or
Let's say the statute said
something.
you have to serve the secretary, and it meant the current secretary, not the one that was, you know, and you interpret it to mean the one that was in secretary when the event occurred, so you served the old secretary. What kind of mistake is that?
So if that was under the federal case law, that would fall under Rule 15, and under the federal case law, mistakes in fact, identity of the party, or mistakes in law are applicable for that. Here, under the Buren test, it's not mistake in law, and it certainly is not a law office failure, because if it was a law office failure, then it would just open up Pandora's box that, this particular amendment to a pleading could be used to escape that. The Buren test doesn't talk about that, CPLR doesn't talk about that, and even Rule 15 doesn't talk about law office failure being the escape hatch if you knew of a party and didn't name them, didn't identify them, or serve them.
Does prejudice come into that analysis?
I think it does. Again, I don't look at the record here and see where we on our side developed any particular prejudice argument for either Rosa Kuhn or Perry Kuhn. But yes, it's a factor that I think the courts have to look at. If I could, just for a couple minutes on unity of interest. The case law, whether it's state or federal, is clear that the unity of interest has to be the same juror relationship. They have to have vicarious liability for one another. And here, there's even a case, I think it's the state court, that said just the simple landlord-tenant situation alone is not unity of interest. And so here, there just can't be Rosa Kuhn, who's in her 70s or early 80s, who happens to reside at the property, has nothing to do with the manufacturing companies. There just is no unity of interest. So
Well,
even,
the appellate division didn't actually analyze this prong and decide this issue, correct?
I don't think they decided it.
Right.
I think
they
in the
assumed it, right? They assumed
I
it.
think it's still a viable issue for this court.
Well, could we, let's say we disagree with you on this question of the mistake. Is there any reason not to simply send it back to the AD and let them address this other prong? As opposed to us addressing it in the first instance?
I would encourage you to address it in the first instance because the record is the record. It's not going to change. And the unity of interest, whether factually or the law, is not going to change. And while maybe this isn't a salient argument, we had a bench trial in 2010 with Judge Fitzgerald, who's now at the Third Department. And here we are in 2013 over this same case. It really has to come to an end, and I would ask you, if you can include that and not send that back down, that would be much appreciated. I think that's what I have for my argument. Thank you very much.
Thank you, counsel.
So counsel, Buren does speak of a mistake as to the identity of the parties. And counsel's point is well taken that this seems broader than just a mistake as to identity. So what is the type of mistake that we are now theoretically expanding to? Is it any mistake? Is it a law mistake? Is it law office failure? Is it any non-strategic mistake? What are we looking for?
I think it's any mistake, and I understand that Buren said mistake as to the identity of parties, and if you go also back to the Mondello case, which we cite in our briefs, Mondello actually used the term mistake, I believe, I don't have it in front of me right now, but something along the lines of, and I quote it in the brief, mistake in properly identifying the parties or something like that. I think that's the better phraseology for it, and I think that's more consistent with, regardless of what Buren
Does that phrasing cover a whole mess of sins, that mistake as to the identity of a party doesn't?
I think it does. I think it does. And mistake as to the identity, as Krupski,
I'm sorry, so is the point of that the focus is the action of the party that fails to name someone as opposed to the identity of who they fail to name?
and that's
Is that your
why
point
I
with
think
that?
identity of the party as opposed to identifying, meaning naming or, joining the appropriate parties, is the wrong approach, the latter being the right. Because I think if you say identity of the party, you're looking more at the plaintiff's state of mind and what they knew and or should have known versus the defendant's state of mind and what they knew or should have known. Which is why I think even though Buren, when it recited the Brock test from the Second Department, and Brock had used that language, what it actually held, I think, is more consistent with the phraseology that this court used in Mondello. which is identifying the proper parties. Again, I have the specific quote in our opening brief. I just want to address counsel's point about early on and whether we could, even if we had amended, I think there still would have been a relation back problem because the statute of limitations here is 30 days, and they interposed their answer well after that. So even if we amended, then they would have said, well, you're amending and adding her too late. But I would also note this gap of 4 years wasn't because we waited 4 years to add her. It's an Article 78 petition, which we filed in August of 2016. They filed their answer and asserted failure to join a necessary party. Your Honor, may I finish?
Yes, please, of course.
Thank you. And then we filed the reply to that, in which we specifically said, we argued Rosa Kuhn's not a necessary party, but even if she is, the court should join her under CPLR 1000B and relation back should apply. We've been arguing relation back since that reply to their answer in the Article 78 when it was first filed in 2016. The reason it took so long is because we then had to go up to the Third Department when Supreme Court held against us on that issue. Third Department didn't address relation back. It just said, no, the court should have joined Rosa Kuhn under 1000B and then allowed her to assert whatever defenses she wanted. We went back down. We amended the petition. There was a delay in that because there was an order from the court that parties never got. I'm not going to get into the minutiae of that, but in any event, we ended up amending the petition, and then they asserted that defense, and we argued relation back again, and we had to go back up to the Third Department. So that's why the timing took too long. It wasn't anything dilatory or intentional on our part. We've been arguing relation back since the very beginning. And I would just agree that this court can and should address unity of interest if it can reach that issue, given the time that's gone by. I think the issue's been properly joined.
Thank you, counsel.
Thank you very much, Your Honors.